Welcome back, everybody. We are going to break out of testimony in the Sean Grade case in Ohio. If you would like to continue watching that, you can always go to our raw feed on lawandcrime.com, click on the live tab, or look on the right-hand side of your screen, and then you'll see all the raw feeds as they come into us. The reason we're going to break out of that testimony is because we're joined by a guest here on the Law and Crime Network. Amanda Clarke Palmer was one of the defense attorneys for Tex McIver, whose murder case wrapped up not too long ago. You remember we covered it live, gavel to gavel, here on Law and Crime. Amanda, welcome to Law and Crime. It's good to have you on our broadcast today.
Thank you for having me.
I'm here with Dan Shore, who's managing director of Kroll. He's a former prosecutor, and he's going to jump into this discussion a bit as well. We know that this ultimately resulted in a conviction for your client. So I wanted to start off by asking your reaction to the verdict. To us, it seemed like a bit of a surprise, but what was your reaction to this?
I was surprised. I'm still stunned at the verdict because of the way the jury came back with their not guilty verdict on malice murder, but their guilty verdict on the aggravated assault and the felony murder charges. Those verdicts to me seem logically inconsistent. And I'm surprised because I think the jury was extremely intelligent. One of the smartest juries I've had in the cases that I've tried. They were asking smart questions throughout the whole trial. So I was surprised, and I'm still surprised, and I think it was just grossly unfair to Tex.
How is your client doing?
He is, I think, holding up as well as one could expect. He's looking forward to, okay, what do we do next? You know, what's going to happen with the appeal, and how do I continue fighting?
So what concerned us legally about this entire situation is the verdict, as you said, because the jury acquitted of malice murder, as you call it in Georgia. That's the top charge. That's basically intent to kill someone. In other words, he didn't, in the minds of the jurors, want his wife dead. What they did instead is they kind of got at murder through the back door and then got it in the front door under what's sort of a bizarre quirk in Georgia's law, because most states wouldn't allow this. What they did is they said this is an aggravated assault. So there's two things at play there. There's an assault and then there's aggravation. An assault is an attempt to violently injure under your state's law, and it becomes aggravated when a number of circumstances are present, two of which were factually present here. There was a gun and it was in a car. So you've got the aggravating factors, but the underlying aggravated assault is an attempt to violently injure, okay? And there's intent to violently injure. The verdict basically says legally that it was an accident that the victim died here. In other words, he didn't intend the death, he just intended the injury. But the state's whole case was that, look, he wanted his wife dead because of financial reasons, because of property that would have passed according to a will. How could this jury possibly find aggravated assault in conjunction with the financial issues? Because if the intent is only to injure someone violently, that's going to add to the financial burden that Tex McIver would be facing.
I don't know that I have an answer to your question, because I agree with how you laid it out. Just factually, it doesn't make sense with the evidence that the state presented. I think the jury, by their verdict, indicated they don't think that Tex intended to kill his wife, but they do think that he was responsible for her death. And if that's what they thought, then involuntary manslaughter would be the appropriate verdict, because involuntary manslaughter is when a death happens and the death is unintentional, but it results from, some underlying criminal conduct. And in this case, the underlying criminal conduct that the jury didn't find, but that they were presented with the option to find, was the reckless conduct.
Yeah, I mean, there's recklessness, there's criminal negligence, and there were a couple of other charges in the mix there that seemed like they would have met this factual scenario. Why did the judge leave this charge on the indictment after the beginning of the case went by? Meaning the felony murder charge.
I don't think he had any option to not include it, unless he was going to grant a directed verdict on the malice murder charge, which he did not do. And since he did not grant that directed verdict, he said there's enough evidence here that it ought to go to the jury. He had to leave the felony murder charge and the aggravated assault charges on the indictment for the jury's consideration.
One thing that sort of struck me as odd sitting here where I'm looking at state laws across a number of states is that in most states, you can't get to felony murder on an aggravated assault. Felony murder has to kind of come out of a completely separate transaction or occurrence. For instance, New York law, where I happen to sit right now, and Dan, you're nodding your head yes here. In most states, to sort of prevent what many here have said online is some kind of a miscarriage of justice in Georgia, to prevent that issue, in many states, felony murder only applies to some separate transaction, some felony unrelated to the act of hurting the victim. It's got to be a kidnapping, a rape, a bank robbery, something like that, an arson. There's a specific list of felonies that if a death unintentionally occurs as part of those underlying felonies, then it can become felony murder. Georgia doesn't do it that way, and my understanding is Georgia's in a pretty extreme minority here.
I don't know. I have not surveyed other states to see what their, various murder charges are, but you're right. We don't have degrees of murder in Georgia. We have malice murder and felony murder, and while they have different elements, unfortunately, they carry the exact same punishment. So you can end up with a situation like we have here, where the underlying felony is something like aggravated assault as opposed to, an armed robbery or a kidnapping or something like what you said. And you have a situation where the defendant gets acquitted of the malice murder, and yet he's stuck with the life sentence that the judge has to impose on the felony murder charge.
Dan, I know that you were sort of reacting to this. You're a former prosecutor. How do you sort of look at this from a perspective of a different state here?
Well, certainly in New York, if you assault someone and the person dies and there's no intent to kill, you're not going to have a felony murder conviction. So that wouldn't happen here. Georgia's different. One thing I wonder, looking at this case, is, some would argue that the defendant wasn't the most sympathetic defendant, even if he had not been proven guilty of the crimes charged. Does that weigh in your mind when you're trying a case like this, that the jury may be tempted to try to find some charge to convict the defendant on because they don't want him walking out free because of conduct that might not be criminal but might be distasteful to them, how he acted afterwards and things like that?
Yeah, absolutely. That was something that we were concerned about and we tried to address in closing. I think both Bruce Harvey and Don Samuel spoke to that in their closing, that, look, the prosecution has done a good job of proving that, Tex didn't act right, or that maybe he's not a good guy or a nice guy. But that's not the question that the jury was supposed to decide. And I don't know exactly that they based their verdict on, a dislike of Tex McIver, or was it more, a combination of the Allen charge that the judge read to them and maybe them feeling like they had to reach some verdict and they were not allowed to remain as a hung jury, which is where they were, 2 hours before they came back with their verdict. And, we never disputed the fact that Tex was responsible for Diane McIver's death. We just argued that it was an accident, and I still believe it was an accident today. So I can understand the jury saying, well, we want him to be held responsible for something, because he is responsible for her death, even though he didn't intend it.
Well, we got a couple of issues wrapped up here, so let's sort of peel this apart here. So first of all, the dynamite charge, the Allen charge, about half of the states say that they won't use it because they're afraid that it's compulsory, that it'll shove a jury into a verdict that the jury might not otherwise reach. Georgia is one of the states that allows it. About half of the states don't. So it sounds like that issue is getting teed up again here. But look, we had one of the jurors, Juror 61 here on Law and Crime last week, and she said that they always were going to convict of something because they came to the determination early on that guns don't go off accidentally, which is what the state kept saying in its case, and which you disputed. So apparently the jurors got to that and then just said, okay, well, the gun didn't go off by itself or accidentally, and they therefore had to find that somehow he had manipulated it or his finger was on the trigger. I asked the juror, okay, well, explain that to me, and she said, well, and I asked her specifically, look, the state's expert accidentally triggered the gun, which of course was unloaded, on the witness stand, which the defense, your co-counsel, used one of our clips in closing argument to drive that point home. She said that the jury just dismissed that and said, well, he was playing with the gun, which you're not supposed to do. And that apparently my understanding is that some of those who had gun ownership experience on the jury just kind of said, well, you're not supposed to play with the gun. Guns don't go off accidentally, and therefore that's what they use to find intent. It is my understanding of how they got there.
Yeah. Well, that certainly sounds a lot more like reckless conduct than any kind of intent, which would have been the basis for the involuntary manslaughter verdict. But unfortunately, that's not what they came back with.
So, again, we're back to one of the other sort of issues here where they're saying you don't aim a gun at something unless you intend to shoot it, and guns don't go off accidentally. These sound like things that come out of gun safety classes, not out of law books.
Yeah, agree. I think, it certainly makes common sense. I don't even know that you have to attend a gun safety course to understand that you ought not to point a gun in somebody's direction, loaded or unloaded. So I think from a common sense point of view, that sounds like reckless conduct, but I don't see how that gets to intentional conduct and intentional pulling of the trigger, especially if the jury relied and accepted the comment that he was playing with the gun. Well, then that sounds more like reckless conduct as to, an intentional pulling of the trigger with the intent to cause an injury or the death of your wife.
Forgive me for not knowing the facts about this particular microcosm of this, but jurors seemed to have a lot of questions about conducting what sounded to me like their own little trial back in the jury room. They wanted the gun, they wanted to take the gun into the car, they wanted the car, they wanted to sit in the car, they wanted to sit in the car together. Now, at what point, and this is a two-part question, does that somehow trigger an issue with the confrontation clause? Because then you have one juror getting information and bringing it back into the jury room saying, well, I saw it this way, and then a juror kind of becomes an expert witness that you can't cross-examine. That's one issue that I saw with that. And also, what's it say about burden of proof? Because if the jurors need to be back there conducting all their own experiments, then isn't that suggestive that the state didn't prove its case beyond a reasonable doubt?
I think those are two excellent points, and we certainly objected to the jury being able to revisit the car, and definitely being able to revisit the car with the gun. The court's analysis and the prosecution's point of view was, well, look, in jury deliberations, they have the evidence back there. They're allowed to manipulate the evidence in the jury room. And in fact, jury deliberations are secret. So they may be doing things back there that we don't exactly know what they're doing. But we raised the issue that it was problematic, not only for the reasons you highlighted, but in addition that we couldn't then re-argue that issue. Hey, you guys need to keep in mind the fact that, for example, y'all aren't the same height and weight as Tex McIver. So when you get in the back of the car, maybe you're not positioned the same way he would have been. And the jurors were getting in the front seat, the driver's seat of the SUV. So we couldn't argue to them, here are the things that you need to keep in mind, the differences. I presume they were sort of reenacting what Danny Jo could have seen and would have seen when she was driving the car. I don't know that for sure because nobody told us that, but that was my, inference based on watching them when they were doing that. So we couldn't argue to them, hey, here are all the other things you need to keep in mind in regards to your little, experiment or reenactment, whatever you want to call it. So that's something that we will definitely be pursuing on appeal.
It seemed to me that for almost every single position that the state took, that you had something reasonable to rebut it with. And usually when I see cases like that, that sounds a lot like what reasonable doubt is. The state says Tex McIver's salary is going down. Well, you're pointing out that he's above the age of 70 and he's transitioning out of a partnership role at his law firm. That happens all the time. The state's insinuating something funny is up with this masseuse. Well, you get the masseuse on the stand who says there's no funny business going on. It was issue with rebuttal. It was fact with rebuttal. And what do you make of this situation with the masseuse?
Well, I thought that was, the state made a comment in their closing argument about Tex acting, immorally or something like that. I thought that was wrong.
It sounds like character evidence. I didn't realize that we convicted people based on character evidence.
Exactly. I mean, they wanted to paint Tex as the guy who, wasn't acting right, and maybe had some sort of, lurid intentions towards the masseuse, and they kept calling her the masseuse during the trial, right? Every time somebody would say Annie Anderson, the prosecution would say, oh, Annie the masseuse. And I thought that was not only unfair to Tex McIver, but terribly unfair to Annie Anderson. And I thought when she got up and testified that she came across as sincere and genuine. And I think that came across to the jury as well.
Ultimately, I guess it boiled down to this presumption that guns don't go off accidentally. And that's at least from what I've heard from the juror that I spoke with, that's how the jury based the decision here. I'm struggling to figure out where the intent was in that, because if the state's theory is correct, that Tex McIver somehow wanted to get rid of his wife for financial reasons, that why would he just want her injured? That's going to rack up bills.
Right. That's right. That seems like you would be, that action would be at odds with somebody who was, wanting to cut back on his expenses. Why take the risk that you wouldn't kill her, that maybe you would injure her or paralyze her or just end up with these, gigantic medical bills? But I still go back to the very first thing I said in my opening statement was, don't forget that the number one reason Tex McIver didn't intend to injure his wife is because he loved her. And every witness got up and testified that they had the perfect relationship. And even the state was reduced to arguing in their closing, well, we don't know what happens behind closed doors, which I thought was sort of a implicit acknowledgement that every single witness got up there and said they seem to have the perfect relationship.
Well, if the state doesn't know, then the state hasn't met its burden, is the way that I would respond to it. But then we're getting into more hypotheticals. Let me ask you about this. Who was on the jury? Generally speaking, what sort of person was on the jury? Were they paying attention? Were they engaged? What was that like? You can see the jury, we can't.
So the jury, I don't remember exactly sort of the demographical makeup right off the top of my head, but I want to say that it was maybe evenly split between men and women. We had a lot of professionals on our jury, people not only with college degrees, but advanced degrees. A lot of people who were, fairly high up in their careers and in leadership positions. I thought they were all dialed in the entire time. There was no time where we looked over and we thought, oh, that juror's asleep again. It's clear that they were giving us their attention for the entire 6+ weeks of trial. And we know that also by the questions that they were asking. I mean, they asked very smart questions, questions that showed they were paying attention to the evidence, and they were linking back one witness's testimony with something that had been, testified to before. So overall, it was a jury that was paying attention, taking notes, and really keyed in.
This was a high-profile case. A lot of people were watching it locally. We were watching it nationally. It's received national commentary. So what's it like to be defending the guy who's sitting in the defendant's chair on a high-profile murder case?
Honestly, kind of at the end, it's like defending every other client. You sort of forget that the cameras are there. You forget that the media is there reporting on your every single, move and every question that you ask. And ultimately you just sit and focus on how do I give Tex McIver the best defense that I possibly can, because he certainly deserved it.
What's next? An appeal? How long do you have? I'm assuming you're going to file for one. Any sense of how you're going to go at it?
We have to wait until sentencing before we can file a motion for new trial, which is the first step here in Georgia. So within 30 days of his sentencing, we will file a motion for new trial. It's sort of a almost a form motion that you just file to stop the clock. And then we have to wait for the transcripts from the trial to be prepared. And once those are prepared, we can then file a more substantive amended motion for new trial. So the first person we go back in front of is the judge, the trial judge, and we ask him to, revisit the verdict. He has the discretion in Georgia to act as a 13th juror, and if he thought that the verdict was against the weight of the evidence, he has the authority and ability to overturn the conviction. He can also review any legal errors that we raise in our motion for new trial. But if he denies our motion for new trial, then the next step would be to appeal to the Supreme Court of Georgia.
So we can expect that to move along. Anything that I missed that is just eating you alive that you've got to get across to people?
No, actually, I think you have covered. I have been watching your interview with Juror 61 and the post-trial coverage you all have given to Mr. McIver's case. And I really appreciated the questions you asked of Juror 61 because you hit on some things that were kind of bothering me and nagging at me as well. So I appreciate your interview with her.
I try to find facts as best I can. So I do have one last question, and it has nothing to do with this case. I ask it of everyone who joins us here at Law and Crime, and I think the answers are illuminating. Why is it that you like your job? What is it that you like the most about being an attorney?
Why do I like my job? I decided I was actually an engineer before I became an attorney. And I decided that I really wanted to do something where I could work with people and help people and use, the abilities and the knowledge that I have to help people. And both my parents are lawyers, so probably a little bit in my genes as well. But this job gives me the opportunity to work with people on a daily basis, to work with good people who find themselves in stressful situations or situations where, they're being unfairly accused and unfairly targeted. And I really enjoy being able to guide people through those challenging situations.
Good response to a question I ask of everyone here. The answers are illuminating. I had one person say, I love cross-examination the most. And it was very telling because the person was very skilled at it. So appreciate you joining us, Amanda Clarke Palmer, defense attorney for Tex McIver in his recent murder case. We'll talk again, I'm sure.
Thanks for having me on.
All right, Dan Shore, some reaction. Sounds like the mind of a criminal defense attorney at work there.
Right, and it was interesting. She did acknowledge there were problems with her own client, that the jury might not like the client, and that might have contributed to this verdict. It had to be quite a moment for them when they hear the first count of intentional murder, not guilty. You would think at that point you're looking at a series of not guilties, especially after some of the earlier juror notes about how they were deadlocked. So to have that be followed up by a conviction on felony murder, which doesn't even make sense, that must have thrown them for quite a shock at the time.
Yeah, especially after, as you said, those questions that were coming out of the jury room. So look, let's put this conversation on hold. It looks like we're probably going to be back to this case because it's such an interesting case. We heard that there's a promise for an appeal. We'll be keeping an eye on that. We're going to go back to the Sean Great case in Ohio now. Again, the case of a man accused of rape, murder, you name it, multiple murders. Right now in court, images are being shown to the jury of the apartment of one of the victims in this case, one of the victims who did not survive. That's the allegation. Those are the pictures. Let's cut back to that case in Ohio.